I'm Alex Berger, trial attorney in the Upper Peninsula of Michigan, and this is an 8-part informational video about the jury trial process in the state of Michigan. Please enjoy. Any jury trial really begins when a complaint is filed or someone's charged with a crime. From that point, everything is geared toward having a trial where that person or that claim needs to be proven. If it's a civil case, it's by a preponderance of the evidence. If it's a criminal case, the case has to be proven beyond a reasonable doubt. But everything is on a trial track. This video is going to explain some of the typical things that occur in the pre-trial phase of any jury trial. One of the most important things in a jury trial is limiting what information the jury can hear. Because if it hears information that's either illegal or not reliable, it can taint the outcome of the trial. So we typically do what's called filing motions to try to clarify, limit, or expand whatever evidence can be admissible at the trial. In trial procedure, these are called motions in limine. In limine is Latin, which means at the threshold. Basically, it's trying to clear up any issues for trial before the trial even begins. In a typical impaired driving case, I will file motions in limine to exclude the type of opinion evidence that officers can give, exclude some of the evidence about the blood test or breath test, exclude evidence of statements that were made by my client if they were unconstitutionally obtained. There are several things that I routinely ask to be limited. Prosecutors, plaintiffs' attorneys, they also file motions in limine to make sure they can get in evidence or limit what the defense can admit. The other thing that we typically do is we do a witness and exhibit list, which we're required to by statute and court rule, which just lays out the exhibits that we're going to use and who or what witnesses we're going to call. That's typically filed in advance of the trial, and then we make objections to the witness and exhibit list if there are some problems with the exhibits or the witnesses. And the other thing that we do is we file jury instructions, preliminary jury instructions for the judge to review for the trial. Finally, we do have what's called a final pretrial conference or a case management conference, usually about a week before the trial, just to touch base between the attorneys and the judge to make sure we're on track and make sure everything is in line. The one other thing that we always obtain before trial is a list of the potential jurors and their juror questionnaires so we can start to object or think about or research the jurors that are going to be on the panel. Once we do all of those things, file pretrial motions, submit our witness and exhibit list, submit our proposed jury instructions, attend the final pretrial conference or case management conference, and get the jury questionnaires and jury list, we are typically prepared to meet one final time at the morning of trial to discuss any final issues. In this video, I'm going to talk about jury selection, which is a very important phase of the jury trial process. So it is the day of the jury trial. We've all been preparing and leading up to this. The attorneys have met with the judge and are ready to go into the courtroom. Everybody files into the courtroom, and the very first thing that we do is select a jury. So for misdemeanors and lower level civil offenses, it's a 6-person jury. For felonies and more serious cases, it's a 12-person jury. They typically request that about 4 or 5 times the amount of people that are going to be on the jury appear for the jury selection process. So for a typical operating while intoxicated case, we'll have about 40 or 50 people that'll be in the courtroom. Judge will introduce the case. Judge will talk a little bit about what's going to happen, how long the jury trial is going to be. The judge will ask if anyone has any medical conditions that might prohibit them from sitting for that long. Judge will ask if anyone has any commitments in their life, either professional or personal, that might make it very difficult for them to sit on the jury. People who answer those questions may be dismissed right out the bat. Also, anyone who obviously has a conflict, like I've had my paralegal be on the jury panel, and they were excused right away. So after the judge has kind of asked the preliminary questions, then the judge has the clerk call out the names of 6 or 12 individuals to come up and actually sit in the jury box for the attorneys and the judge to ask those people questions specifically. So what you have is you have a bunch of people in the back of the room, then 6 or 12 people come up and sit in the jury box. Sometimes they add an extra person, a 7th or a 13th, and those are alternate jurors. What they do is they select the jury and then an additional person. They don't say who that person is. But if someone were to get ill or get killed or, not show up and just disappear, then the alternate would step into their place. So that's why they do that. Typically in misdemeanor cases, they do not have an alternate. So they bring up the 6 or 12 people into the jury box, and then the plaintiff's attorney, typically the prosecutor in a criminal case, gets to ask the jurors questions first. They ask them about their bias, about their personal history, about anything that might be relevant to the case. The purpose of jury selection is to select an unbiased and fair jury. So the questions are supposed to not lean one way or another. And then after the prosecutor or plaintiff's attorney gets done asking questions, they get to strike anyone for cause. Like if someone said, let's say it's a car accident case where they're trying to get damages for injuries in a car accident. If one of the people on the jury said, my son died in a car accident, and I think that people who have someone die in a car accident should be given as much money as possible. I don't care what happened. That would be an instance where the defense attorney may ask for that person to be struck for cause. Then the defense attorney gets up and does the same thing. Some attorneys think that jury selection is a good time to educate the jury about things you want them to know. Some defense attorneys or plaintiff's attorneys think that it's time to see who's a really bad fit for the jury and then make sure they get off. There are a lot of different thoughts on this. This is the best book that's ever been published, in my opinion, on jury selection and jury thinking. It is Practical Jury Dynamics 2 by Dr. Sunwolf, published by LexisNexis. It is amazing. I've been to probably a dozen jury selection seminars, and this book has been brought up more than once in those, and it is just a treasure trove. But I'll move on. After the defense attorney asks the questions and strikes anyone for cause, then each attorney gets to strike people for no reason whatsoever. They typically get between 3 and 6 strikes each. So, if I'm the defense attorney, my client's sitting next to me, and I typically have a paralegal with me, we'll look over the jurors that are on the panel and we'll decide who we want to strike. Sometimes we don't strike anyone, but we usually strike a couple people. This is where I really give my client input. If they get a bad feeling about somebody, I'm going to go with their instinct unless I have a good reason not to. All attorneys that do jury trials have a system for how they keep track of jurors. If someone is removed for cause from that panel of 6 or 12, or if someone is struck with what's called a peremptory challenge, which is where they get to take someone off the jury for no reason whatsoever, then that person is removed and they call up a random other person from the back of the room. So it's kind of this musical chairs thing where you get to ask questions of the new people that show up. So we ask a lot of the questions over and over again, but eventually we go through our peremptory strikes. We strike everyone that's for cause, and then we're left with people that we don't have any more objections to, either 6, 12, 7, or 13 if there are alternates, and that's when they select the jury. Everyone in the back of the room is free to go. They have the jurors swear an oath, and then they are the jurors. Typically after that, we take a break, and we roll right in to opening statements. This video is going to talk about opening statements in a jury trial. This is one of my favorite things to do as a jury trial practitioner. It's the first real thing that happens in the jury trial proper. So prior to opening statements, a jury has been selected. They have been impaneled. They've been sworn to be jurors and to not talk about the case until they're deliberating and look at all the evidence fairly. The judge gives them some preliminary jury instructions just about what to look for, what to do, what not to do. And what the elements of the crime are, or the elements of if it's a civil case, what the complaint says, what they need to prove. And then the judge turns it over to the plaintiff's attorney. In a criminal case, that's the prosecutor. The purpose of opening statements are to give a summary of the evidence that the attorney that's speaking expects will be presented to the jury. It is not supposed to be argumentative. It's not supposed to be adversarial. And it's supposed to clearly stick to evidence that the attorney believes will be admitted at the trial. Occasionally, attorneys will use actual video or document evidence in their opening statement. Sometimes they'll have PowerPoint, which kind of lays out what they're talking about, has fancy transitions and pictures and that sort of thing. Any evidence that an attorney tries to use in opening statement must be agreed to be used by the other party. In OWI cases, I routinely play the dash cam of my client driving in the opening statement if the prosecutor agrees, just to hammer that home. But the prosecutors just generally go through what they have to prove, how they're going to prove it. They talk about what different witnesses will say, what different documents will say, and then they conclude. And then, if it is a criminal case, the defense attorney can give an opening statement right at the beginning after the prosecutor, or they can not give one at all, or they can delay it to after the prosecutor's case. Vast majority cases, over 99%, that go to jury trial in Michigan, the defense attorney gives their opening statement right after the prosecutor. In civil cases, they have to give their opening statement then. Opening statements are really, it's dependent on that particular attorney and what their style is. I like to tell a story. I like to keep it short. I like to say it in the present tense, first person whenever possible. And I like to make my client really just a, kind of innocent, involved person in the case. But I've honed my opening statements. I've gone to many seminars about how to give opening statements. I've read several books about it. But it is really up to that attorney and how they choose to go about it. Opening statements are not evidence. The jury can disregard them completely. But they are an important part because they preview for the jurors what is going to happen. And from an advocate, the attorney's perspective, we get to watch the jurors while the other person's talking and watch them while we're talking and get a sense for what sort of arguments are persuasive and what sort of arguments have them shaking their head. But it is a critical stage. And then after opening statements, we move on to the plaintiff's case in chief, where they start putting on evidence. I'm going to continue my discussion of jury trials today, talking about the prosecution or the plaintiff's case in chief. So we just finished opening statements. You got some jury instructions for the jurors. They are ready to go into the case. And now we proceed to the evidentiary portion of the trial, which is truly the most important and most consequential part for the jury, at least. So who we have at the tables? We have the plaintiff or prosecution closest to the jury because they have the burden of proof. They get to be closer to the jury than the defense. At that table, we have the plaintiff's attorney or attorneys. If it's a criminal case, you have a representative of law enforcement there. If it's a civil case, you have someone from the plaintiff's side. So if it's an individual there. And if it's a company, it's a representative for the company. On the defense side, we have the defense attorney or attorneys, maybe an assistant or two, a paralegal, and we have, of course, the party. If it's a civil case, it could be a representative of a company. In a criminal case, it's the defendant. And so we have those people at the trial, at the tables. They get to stay in the room the entire time. There is something that's ordered in almost all civil or criminal jury trials called sequestration. And that means separation. And the purpose is you don't want a witness hearing what all the other witnesses say before they testify. It could affect their testimony or affect their memory even. So we like to keep witnesses that haven't yet testified out of the courtroom. That's called sequestration. That does not apply to anyone that's allowed to sit at the table. So it doesn't apply to one of the law enforcement officers in a criminal case, doesn't apply to the defendant in a criminal case, and it doesn't apply to any of the parties or the representatives that are at the tables. Even though they may testify, they get to hear everything. So we have now all of the witnesses that aren't sitting at the table out in the hallway. We have the people and their attorneys at the desks, at the tables in the courtroom facing the judge. We have the jury closest to the plaintiff. And then the plaintiff's attorney calls their first witness. They are required to put on evidence because they bear the burden of proof and the burden of persuasion. So they call up a witness. That witness is sworn under oath. And then the plaintiff's attorney proceeds to ask questions in direct examination. And these are open-ended questions typically. So what did you do on August 15th of 2024? What did you do next? What were you looking at that time? Open-ended questions that allow for a narrative response. Those are typically what an attorney does on direct examination in their case in chief. And the other part of this testimony that's very important for the plaintiff is our judicial system with evidence is testimony-based. It is individuals testifying under oath that forms the foundation for all of the evidence that we get in. Now, there's a lot of documents and videos and that sort of thing that come into evidence. Those almost always go through a witness. So if you have a picture you want to introduce into evidence, you have a witness say that that is a true and accurate picture of whatever it's depicting. Same thing with a video. If it's a document, you need someone to authenticate that document, lay the foundation for how it was produced and what the information on it is and how it was sourced. So the testimony really drives all of the evidence. It is how you also get in documentary evidence, video evidence, and that sort of pictures, words, that sort of thing that goes in front of the jury. So you admit exhibits evidence through testimony. After the plaintiff's attorney has asked all of their open-ended questions, got in all of their evidence from a particular witness, then it is the defense attorney's opportunity to do cross-examination. Cross-examination is not open-ended questions. It's supposed to be leading questions, and that's stating a fact and asking them to confirm or deny it. So, you murdered her on August 15th, 2024, didn't you? That's a leading question. That states a fact and makes them confirm or deny it. The purpose of leading questions is so that the attorney can control the narrative and the witness can confirm or deny things. Occasionally, we'll ask non-leading questions if the witness has some important information. For example, a forensic toxicologist in an OWI case, they are a treasure trove of information that's helpful to the defense. So I ask them some questions about the science that's just helpful to my case where it's not a leading question. After cross-examination is complete, then the plaintiff's attorney gets to do redirect examination, and that is just an opportunity to clean up anything that went wrong on cross-examination or any facts that got mixed up or anything they need to, fix in what their witness said. After redirect examination, the defense attorney could typically do recross, which is the same thing. They kind of pick apart what was happening on redirect, and that can go back and forth a couple times. Typically, judges will cut it off after 1 or 2 rounds. And then after they finish the actual examination of a witness, the judge can ask questions of the witness, and the jury can ask questions by writing them down and handing them to the judge. Now, the jury's questions are allowed by court rule, but the judge is also permitted to not allow jury questions. It's hit or miss in the Upper Peninsula. About half and half judges allow jury questions. Personally, I love jury questions. They're fascinating. They allow us to see into what the jurors are thinking mid-trial so we can focus on certain things or not focus on certain things. And so I always encourage jury questions. I always ask the judges to allow them. Oftentimes they don't. And then we move on to the next witness. This goes on until the plaintiff has called all the witnesses that they believe they need to prove their case. And then the next part after they say that they have no more witnesses is the defendant's case in chief. This video will talk about the defense case in chief in a jury trial. So in terms of the trial process, the prosecution or the plaintiff's attorney has just rested their case. They've called their witnesses. They've admitted some evidence. The defense attorney has gotten a chance to cross-examine any of their witnesses. And the judge says, "Defense attorney, are you ready to proceed?" Typically at this stage, the jury will leave the room so that we can address some matters outside the presence of the jury. This is common during a jury trial. There are certain matters, particularly that deal with evidence that we're not sure the jury is going to hear or objections, that we will talk about things outside the presence of the jury. Also, jury instructions are dealt with outside the presence of the jury. We just deal with legal things with just the attorneys, the parties, and the judge. So the first thing that we can do is what's called a motion for directed verdict. This happens in both civil and criminal cases. And basically, you are asking the judge to take the case outside of the hands of the jury and let the judge decide it. The standard for this, and I'm paraphrasing a little bit, is that no rational juror could find that the plaintiff has met their burden to prove their case. In a civil case, that would be a preponderance of the evidence. In a criminal case, it would be beyond a reasonable doubt. These are rarely granted, but I've had 1 or 2 granted. I know other attorneys in the area that have. Typically, it's when a witness went way off track and contradicted themselves, or it's when there's a legal technicality that came out during the trial that makes it impossible for the prosecution or the plaintiff to prove their case. After the motion for directed verdict is dealt with, then in a criminal case, at least I will, and I know other practitioners that do this, they will ask their client in court if they want to testify. So someone accused of a crime has an absolute right to remain silent from the Fifth Amendment of the United States Constitution Bill of Rights, and that is very important and quintessential to a criminal jury trial. what we will do is we'll ask the defendant, after they've heard the entire prosecution case, if they want to testify. They'll be told that if they testify, they can be cross-examined by the prosecution. All sorts of things can come up, and they have to answer truthfully. But they can also choose not to testify, in which case the jury will be instructed that they're not supposed to use the defendant's silence against them. Now, this is tricky. I let my client decide, but I advise them whether or not I think they should testify, but ultimately it is their decision because it's their constitutional right to remain silent. Jurors are not supposed to hold a defendant not testifying against them, but I can tell you they do. It's human nature. You want to hear from the person that's being accused of a crime. In the civil realm, there's no Fifth Amendment implication for the parties. The parties almost always testify. So that's only in the criminal case. Whether or not the defendant elects to testify, we move on to the actual presentation of evidence. In the civil realm, defendants can do counterclaims, which means they have their own lawsuit where they have the burden of proof, in which case they would have to put on evidence to prove that counterclaim. But in a criminal case or a civil case where there is no counterclaim, the defense doesn't have to do anything. They don't have to put on any evidence because the burden rests solely in the plaintiff. Typically, we do end up putting on some sort of evidence. I've had many jury trials where I don't put on a single document or witness. I would say it's about 50-50 where I have someone testify. I have the defendant testify or the defendant choose to testify in a lot of my cases, particularly impaired driving cases, because I think the jury wants to hear how they felt, what exactly they drank or took, any sort of medical issues that were affecting them at the time. All of these things are important. I think the jury benefits from hearing those. So the defendant oftentimes testifies. Sometimes we have other witnesses that saw things. They're not like character witnesses or anything like that. It's all related to the facts that are being alleged. So we call our witnesses. It goes through the same thing that it does for the prosecution or plaintiff side, direct examination, open questions, cross-examination, leading questions, and then redirect, recross. We oftentimes get exhibits in. Sometimes the defense will get exhibits in during the prosecution case in chief. For example, I had a jury trial a couple months ago where my client's driving in an impaired driving case was terrific. No problems at all. And then the prosecution was not going to admit the dash cam, which shows my client's pristine driving. So I got the officer to admit the dash cam. That was a piece of evidence that I got admitted as the defense attorney, but it was during the prosecution's case, or we can do it during our case. Now, one thing I want to talk about here is objections. They do happen a lot in the prosecution and plaintiff's case, but I'm going to talk about it here in the defense case. So there are two types of objections that can happen. There's a standing objection where the attorney stands up, says why they're objecting in front of the jury, and then the parties talk. The judge makes a decision whether or not they're going to allow that testimony or whether or not they're going to strike it, whether or not they're going to allow that exhibit or whether or not they're going to strike it. And then there's bar objections where you ask, may I approach? The attorneys go up to the judge turns on a white noise machine, and then we make the objection outside the presence of the jury. There are strategic reasons why you want to do a bar versus a standing objection. Typically, if you want the jury to hear it, you do a standing. If it's something that you're not quite sure the jury, you want them to hear, then it's a bar. And some judges don't allow bars. Some judges don't allow standing objections. So it's just that particular courtroom. The jury's not supposed to consider whether or not objections are granted or overruled. So they're supposed to just ignore it, but they definitely pay attention. I heard from an attorney I really respect at a seminar last year that whenever you go to a bar objection or even whenever you're doing a standing objection, regardless of how the judge rules, look like you won. It is all about perception in jury trials. I tend to not make a lot of objections just because I think it distracts from the jury and causes problems in the flow. Some attorneys make a lot of objections. You want to create that record in case you have to appeal it. If you don't object to something during trial, then you can't as easily appeal that issue. Next, finally, when the defense case wraps up, they close their case and have no more evidence to put on. The prosecution can do what's called rebuttal, where they put on evidence to contradict whatever the defense said. If the defense did not put on any evidence, the prosecution and plaintiff's attorney cannot do rebuttal. And then there is also something called surrebuttal, which is where the defense gets to put on rebuttal witnesses to the plaintiff's rebuttal witnesses, which, that can go on and on. A sur rebuttal is rare, and anything beyond that is extremely rare. After the case rests, everyone's rebuttals and sur rebuttals are completed. Then the defense rests their case formally, the prosecution rests their case formally, and we move on to jury instructions. In this video, I will be talking about jury instructions in the jury trial process. This is a very important part, but it's not a very publicly known part of the jury trial. And that's primarily because the jury doesn't get to see it happening. It happens outside their presence. So just basically, in a jury trial, there are two judges. There's the judge who sits on the bench in the robe, and the judge is the judge of the law. The judge gets to make final decisions about what the law of the case is. The other judge is the judge of the facts, which is the jury. The jury is as much a judge as the actual judge in the robe. That's why if you've ever been to a jury trial, when the jury stands up, everyone in the room is supposed to stand up just like they would for the judge in the robe, because the jury is a judge. They are the judge of the facts. But the judge has to tell the jury what the law to apply is. And that's what the jury instructions are. So if you remember from previous videos about the jury trial process, there are preliminary instructions which are given before the opening statement. Those talk about the basics of the allegation or the complaint or the crime if it's a criminal case. And they talk about things that the jury is supposed to do and not supposed to do. Like they're not supposed to do independent research. They're not supposed to talk to people about the case. They're not supposed to, talk to other jurors about the case. They're not supposed to talk to people who are witnesses. They're supposed to take notes if they want to. When they can get food, that sort of thing. It's just all of the do's and don'ts that should guide them while they're in the jury process. Now, after the case is done, after the close of the defense's case, the close of rebuttal, then we need to figure out what the jury instructions, the final instructions should be. What is the law that we're telling the jury to use when they're deciding the facts? In the state of Michigan, we have model jury instructions for both criminal and civil. They're fairly comprehensive. They're from the state bar. They involve everything that comes up in cases from the Michigan Supreme Court, the Michigan Court of Appeals. They provide for new statutes or changes to the law. And so they're a pretty good place to start. A majority of cases, almost all the jury instructions are from the model instructions. If you use a model instruction, there's really no basis to object. But in a lot of cases, probably a minority, but many cases, we have to write some jury instructions. And that's when we have to argue about if they're correct or incorrect. I had a case, for example, last year. It was a huffing case, that is inhaling of a chemical agent, which is illegal in the state of Michigan. It's a misdemeanor. That is a rarely charged offense. In that case, it was huffing nitrous oxide through a whippet, which is illegal. And in that case, there was no jury instruction for huffing because it's just rare. So we had to write one, and I wrote one. And it turned out that nitrous oxide probably didn't qualify as a chemical agent and wasn't illegal to huff. So it was through writing of the jury instruction that we actually won that case, which is an interesting example. Then there are things that can come up in trial that require a jury instruction, like if a witness says something they're not supposed to, the judge can instruct the jury that they're supposed to disregard that specific statement. Sometimes the defense or the prosecution has a theory that doesn't quite fit in the model jury instructions, in which case they'll write one, and we argue about it. Sometimes jury instructions get included that we object to, one of us objects to, all of us object to, but if the judge puts it in, then as long as we maintain that objection, we can appeal that issue later. So we have all this discussion in a final jury instruction conference, which happens after the close of all the case, but before the closing arguments. We put our objections on the record, we try to resolve whatever we can, and then we come up with a final version that we're going to give to the jury after closing arguments. Once we get the jury instructions finalized, we proceed to the final phase of the jury trial itself, which is closing arguments. This video is going to talk about closing arguments in the jury trial process. This is my favorite part. So what we've done so far is we did pretrial motions and hearings. We chose a jury called jury selection. We had opening statements, plaintiff's case, defense case, and we chose the jury instructions, or the judge chose the jury instructions, and the judge has turned it over to closing arguments to the parties. So the structure is very simple. Plaintiff's attorney gives their closing argument, defense attorney gives theirs, and then the plaintiff's attorney gets one final statement to the jury called rebuttal. There are 3 parts, and then it goes to the jury after jury instructions. The purpose of closing arguments, notice they're called arguments as opposed to opening statements. Opening statements are just a preview of what you expect the jury will see in the trial. Closing arguments are when the attorneys get to make arguments to the jury that they should find in their favor. So you get a lot more latitude in terms of argument, metaphor, doing inferences, talking about what wasn't presented, and talking specifically about the law and how the jury should apply the facts to the law. We oftentimes use a little bit more tools in closing arguments, as in like PowerPoint or whiteboards, or we wave around exhibits that were shown in trial. The interesting thing about closing arguments is you get to use all the evidence that was admitted during the trial. So you can actually play videos more easily and show documents and specifically quote testimony that was given in trial. Closing arguments are the last time the attorneys get to talk to the jury before they decide what they're going to do with the case. So it's incredibly important. There are 2 principles that really guide me with my closing arguments, and those are primacy and recency. Primacy is the first thing that you hear or say, and recency is the last thing that you heard or said. So I always start off with my most persuasive argument, and I always end with my second most persuasive argument, just so that the jury, when they go back, they remember the important things. I like to keep closing arguments short, but they do sometimes, I've heard them go on more than 2 hours in some complicated cases. One final thing I'd like to say about closing arguments is objections. They're rare in closing arguments because it's supposed to be a time where the attorney can basically, make their argument to the jury, pitch their case to the jury. One thing that you're not supposed to do is you're not supposed to misstate the law. Second thing that you're not supposed to do is misstate the facts that were in the trial. If I hear another attorney do either of those things, I will object. Additionally, in criminal cases, the prosecution has some additional ethical burdens of things they can't or can't talk about. They can't comment on the fact that the defendant used their constitutional rights. They can't vouch for the credibility of a witness. And they can't comment personally on what's going on. So prosecutors have a slightly higher threshold on things that they're supposed to do or not supposed to do. But the structure is that the plaintiff gets the last word. So if the defense is your side, you have to make that one time you get to give closing argument really stick. And the final thing I will talk about is preparation. Closing arguments are a little bit more difficult to prepare than other parts of the jury trial as the trial attorney. I am someone who writes down everything. I don't necessarily read it in trial, but I have the entire trial prepped out. Closing argument is a little bit more tricky because sometimes things come out in evidence that you want to include in closing argument that you simply didn't know before the trial happened, before you heard the evidence. So closing argument, generally for me in my trial notebook, it's just a blank sheet with some bullet points, and then I fill it in and write it during the trial and right before closing argument starts. After closing argument, what we have is the final jury instructions. The jury is sent back to the deliberation room and we await the verdict. In this video, I'm going to talk about the verdict phase of the jury trial. This is the most exciting part because it's when we find out what the jury decided. So what happens is we do closing arguments, which is talked about. We then move on to final jury instructions, where the judge tells the jury the law of the case and tells them what they're supposed to do in deliberation. They're supposed to choose a foreperson once they get back into the deliberation room. That's someone who guides the discussion and reads the verdict to the court. They're supposed to come to a consensus for any decision. They're supposed to keep their own counsel and not change their convictions or beliefs, but they're supposed to discuss the matter. In the state of Michigan, a jury verdict must be unanimous, meaning everyone must agree on either guilty or not guilty, or for the plaintiff or for the defendant in a civil case. And so if it is not unanimous, that's what's called a hung jury. The case is dismissed, and the prosecution or the plaintiff can refile the case if they want to. So after the jury goes back into their room, we typically clear the courtroom and give our cell phone numbers, if we don't have them already, to the clerk or the court staff so that they can call us when the jury comes back, either with a question or with a verdict. We usually are not allowed to leave the courthouse complex because we need to be able to return to the courtroom on short notice. And all the parties, the same thing, they can't leave until a verdict is reached or they break for the day. We do get questions from the jury. Usually they're questions about evidence they can re-see or see, questions about issues of law. In marijuana driving cases, we've gotten a question several times of if there is a legal limit for the amount of Delta-9 THC you can have in your blood. That's the psychoactive component of cannabis. There is not a legal limit, but we routinely get that question. And then the other thing that we talk about a lot with the jury is meals. Typically, jury trials get done in late afternoon. They might deliberate for a few hours, in which case they'll need to be fed. So the judge asks everyone what they want to eat, and they'll order in pizza or Jimmy John's or whatever's available. But we wait, go in for a few questions, talk about meals, and then when a verdict comes out, we get that text or call. Everyone files into the courtroom. We have the jury come in, and then the foreperson hands the verdict form to the judge. Judge reviews it. Some judges will read the verdict from the bench. Some judges will give it back to the foreperson for the foreperson to read. And that's when we find out if it's guilty, not guilty for the plaintiff, for the defendant. In a civil case involving money, the jury will actually decide how much money someone is awarded. So this is a very tense sort of moment when we're waiting for the decision to come out, the culmination of sometimes days of hard work by everyone in that room. So it is a very interesting part, and it's a very important part. Unfortunately, we don't really know what the jury talks about unless they tell us. A lot of times we don't have any idea how they reach their conclusion. We get some idea from the questions that they might have asked during deliberation, but it is a black box. We find out what the decision is, and we don't really usually know why. Now, in a criminal case, there's one final component. In a criminal case, if it's not guilty, the person's free and clear. If it's guilty, then they have to schedule a sentencing hearing. Sometimes in misdemeanor cases, they'll do sentencing right then and there at the end of the jury trial at the verdict phase. But in the vast majority of cases, they will set sentencing for a different date when they'll figure out what the punishment is. The jury has no involvement in the state of Michigan in the punishment for a criminal offense. And sometimes, if it's a serious offense or if it's an offense that involves assault, the judge will put the person in jail right after the verdict if it's guilty, waiting sentencing. I have seen that happen on some misdemeanor cases, particularly when it's a domestic violence situation or something like that. And in some felony cases, it's actually required, like sexual assault, that the person be put in jail right after the conviction. But generally, the verdict is when the case is decided. Sometimes there's a couple of final matters that need to be decided, but that is the conclusion of the jury trial process. Thank you for watching. I do intend on putting out a few more videos about jury trials for specific issues like expert testimony and objections and documentary evidence, things like that. Thank you for watching.